Insurance Code. Mercantile Law. 2. Consideration, which is the premium paid by the insured, for the insurer's promise to indemnify the former upon the happening of the event or peril insured against, and 3. Meeting of minds of the parties. Contract of insurance. It is an agreement whereby one undertakes for a consideration to indemnify another against the loss, damage, or liability arising from an unknown or contingent event. A contract of insurance, to be binding from the date of application, must have been a completed contract. Perez vs. CA, GR number 112329, January 28, 2000. Thus, it must have all the essential elements of a valid contract as enumerated in Art. 1318 of the New Civil Code. 1. Subject matter in which the insured has an insurable interest. 2. Consideration, which is the premium paid by the insured, for the insurer's promise to indemnify the former upon the happening of the event or peril insured against, and 3. Meeting of minds of the parties. Doing an insurance business or transacting an insurance business. The term doing an insurance business or transacting an insurance business means 1. Making or proposing to make, as insurer, any insurance contract. 2. Making or proposing to make, as surety, any contract of suretyship as a vocation and not as merely incidental to any other legitimate business or activity of the surety. 3. Doing any kind of business, including a reinsurance business, specifically recognized as constituting the doing of an insurance business. 4. Doing or proposing to do any business in substance equivalent to any of the foregoing in a manner designed to evade the provisions of the Insurance Code. In the application of the provisions of the Insurance Code, the fact that no profit is derived from the making of the insurance contracts, agreements or transactions, or that no separate or direct consideration is received therefore, shall not be deemed conclusive to show that the making thereof does not constitute the doing or transacting of an insurance business. Q. The parties' CBA contains the following provision: the company shall obtain group hospitalization insurance coverage or assume under a self-insurance basis hospitalization for the dependents of regular employees. Eventually, 3 members of Mitsubishi Motors Philippines Salaried Employees Union, namely, Ernesto Calita, Hermie Juan Obel and Jocelyn Martin, filed claims for reimbursement of hospitalization expenses of their dependents. In turn, Mitsubishi Motors Philippines Corporation paid only a portion of their hospitalization insurance claims, not the full amount. However, MPSU insists that MMPC is also liable for the amounts covered under other insurance policies, otherwise, MMPC will unjustly profit from the premiums the employees contribute through monthly salary deductions. Is MPSU's contention correct? A. No. Since the subject CBA provision is an insurance contract, the rights and obligations of the parties must be determined in accordance with the general principles of insurance law. Being in the nature of a non-life insurance contract and essentially a contract of indemnity, the CBA provision obligates MMPC to indemnify the covered employees' medical expenses incurred by their dependents, but only up to the extent of the expenses actually incurred. This is consistent with the principle of indemnity, which proscribes the insured from recovering greater than the loss. Mitsubishi Motors Philippines Salaried Employees Union vs. Mitsubishi Motors Corp. GR number 175773, June 17, 2013, Indivina 2014. Insurance as an Uberimi Fides contract. The contract of insurance is one of perfect good faith not for the insured alone, but equally so for the insurer. In fact, it is more so for the latter. Since its dominant bargaining position carries with it stricter responsibility. It requires the parties to the contract to communicate that which a party knows and ought to communicate, that is, the duty to disclose in good faith all facts material to the contract. This doctrine is essential on account of the fact that the full circumstances of the subject matter of insurance are, as a rule, known to the insured only, and the insurer, in deciding whether or not to accept a risk, must rely primarily upon the information supplied to him by the applicant, Sundeong Sr. and Aquino, 2014. Insurance as contracts of adhesion. While generally, stipulations in a contract come about after deliberate drafting by the parties thereto, there are certain contracts in which almost all the provisions of which have been drafted only by one party, usually a corporation. Such contracts are called contracts of adhesion, because the only participation of the other party is the signing of his signature or his adhesion thereto. Insurance contracts fall into this category. Sweet Lines, Inc. vs. Teves, Gr. No. L. 37750, May 19, 1978. An illustration of a contract of adhesion is when the insurer used fine print letters in conditions stated in a contract of insurance. Rules in the construction or interpretation of insurance contracts. Gr. If the terms of the contract clearly show the intention of the parties, there shall be no room for interpretation. XPN. If there are ambiguities in the terms of an insurance contract, they have to be resolved in favor of the insured and strictly against the insurer, because an insurance contract, being a contract of adhesion, most of its terms is not a product of mutual negotiation between the parties, as they are prepared by the insurance company in final printed forms. Parties to the contract of insurance. 1. Insurer, party who assumes or accepts the risk of loss and undertakes for a consideration to indemnify the insured on the happening of a specified contingency or event. 2. Insured, person in whose favor the contract is operative and is indemnified. Note: the insured is not always the person to whom the proceeds are paid. 3. Assured/beneficiary, a person designated by the terms of the policy to receive the proceeds of the insurance. He may be the insured or a third party in the contract for whose benefit the policy is issued and to whom the loss is payable. Insurer, every corporation, partnership, or association duly authorized by the Insurance Commission to transact insurance business may be an insurer. The term insurer no longer includes individuals. Under RA 10607. Hence, an individual natural person is no longer allowed to be an insurer. However, it includes the following. 1. Professional reinsurer, any person, partnership, association, or corporation that transacts solely and exclusively reinsurance business in the Philippines. 2. Mutual insurance companies. The law also provides for the procedure for mutualization of domestic stock life insurance companies. A new provision on RA 10607 is on demutualization or conversion of mutual insurance companies into stock corporations, IC, as amended by RA 10607, seconds. 280. 3. Cooperatives are now expressly included in the term insurer or insurance company. However, the cooperative must a. have a sufficient capital and asset required under the insurance code and the pertinent regulations issued by the Commission. B. have a certificate of authority to operate issued by the Commission, which should be renewed every year, IC, as amended, seconds. 193, Sundeong Sr. and Aquino, 2014. Q. Philippine Healthcare Providers, Inc. is engaged in operating a prepaid group practice healthcare delivery system or a health maintenance organization to take care of the sick and disabled persons enrolled in the healthcare plan. Individuals enrolled in its healthcare programs pay an annual membership fee and are entitled to various medical services provided by its duly licensed physicians. Specialists and other professional technical staff participating in the group practice health delivery system at a hospital or clinic operated or accredited by it. Is Philippine Healthcare Providers, Inc. a health maintenance organization or an insurance company? A. HMOs are not insurance businesses. One test that they have applied is whether the assumption of risk and indemnification of loss are the principal object and purpose of the organization or whether they are merely incidental to its business. If these are the principal objectives, the business is that of insurance. But if they are merely incidental and service is the principal purpose, then the business is not insurance. Philippine Healthcare Providers appears to provide insurance-type benefits to its members. But these are incidental to the principal activity of providing them medical care. The insurance-like aspect of Philippine Healthcare Providers' business is minuscule compared to its non-insurance activities. Therefore, since it substantially provides healthcare services rather than insurance services, it cannot be considered as being in the insurance business. Philippine Healthcare Providers, Inc. v. CIR, GR number 167330, September 18, 2009. Persons who may be insured. Anyone except a public enemy may be insured. A public enemy is a nation at war with the Philippines and every citizen or subject of such nation. A public enemy is a nation at war with the Philippines and every citizen or subject of such nation. It does not include mobs, thieves or robbers. If majority of the stockholders of the corporation were subjects who became an enemy corporation upon the outbreak of the war between two states, it stands to reason that an insurance policy ceases to be allowable as soon as an insured becomes a public enemy. Hence, any contingency which may occur during or after said war cannot be indemnified under a policy issued before said war. However, elementary rules of justice and in the absence of specific provision in the insurance law, require that the premium paid by the insured for the period covered by its policy should be returned. The purpose of war is to cripple the power and exhaust the resources of the enemy. And it is inconsistent that one country should destroy its enemy's property and repay in insurance the value of what has been so destroyed. Subject matter of a contract of insurance: anything having an appreciable pecuniary value, which is subject to loss or deterioration, or of which one may be deprived so that his pecuniary interest is or may be prejudiced. Event or peril insured against it is any contingent or unknown event, whether past or future, which may damnify a person having an insurable interest, or create a liability against him subject to the provisions of Chapter I of the Insurance Code. Consent of spouse not necessary. The consent of the spouse is not necessary for the validity of an insurance policy taken out by a married person on his or her life or that of his or her children. Consent of the person insured is not essential to the validity of the policy. So long as it could be proved that the insured has an insurable interest at the inception of the policy, the insurance is valid even without such consent. Effect of death of policy's original owner. All rights, title and interest in the policy of insurance taken out by an original owner on the life or health of the person insured shall automatically vest in the latter upon the death of the original owner, unless otherwise provided for in the policy. Note: prior to the effectivity of the Insurance Code of 2013, the term used was minor instead of the person insured. A minor cannot enter into any contract of insurance with any insurance company. Games of chances cannot be insured, and insurance for or against the drawing of any lottery, or for or against any chance or ticket in a lottery drawing a prize is not authorized. Void stipulations in an insurance contract. Stipulations in an insurance contract which provides 1. For the payment of loss whether the person insured has or does not have any insurable interest in the subject matter of insurance. 2. That the policy shall be received as proof of such interest. 3. Every policy executed by way of gaming or wagering. Note: the Insurance Code provides that a policy may declare that a violation of specified provisions thereof shall avoid it. Thus, in fire insurance policies, which contain provisions that if the claim be in any respect fraudulent or if any false declaration be made or used in support thereof, all the benefits under the policy shall be forfeited. A fraudulent discrepancy between the actual loss and that claimed in the proof of loss voids the insurance policy. Mere filing of such a claim will exonerate the insurer. Elements of an insurance contract. Spear. 1. Scheme to distribute losses. Such assumption of risk is part of a general scheme to distribute actual losses among a large group or substantial number of persons bearing a similar risk. 2. Payment of premium. As consideration for the insurer's promise, the insured makes a ratable contribution called premium, to a general insurance fund. 3. Existence of insurable interest. The insured possesses an interest of some kind susceptible of pecuniary estimation, known as insurable interest. 4. Assumption of risk. The insurer assumes that risk of loss for a consideration. 5. Risk of loss. The insured is subject to a risk of loss through the destruction or impairment of that interest by the happening of designated peril. Note: the inherent uncertainty of events is normally described in terms of risk. A contract possessing only the last 3 elements enumerated above is a risk-shifting device, but not a contract of insurance which is a risk-distributing device. Moral hazard phenomenon. Consequently, however, the existence of insurance could have the perverse effect of increasing the probability of loss. This is when the insured, having in mind the indemnification for loss or damage caused by the happening of the event insured against, would have reduced incentive to take steps to protect himself or his property. Subject of insurance. Casualty insurance. It is an insurance covering loss or liability arising from accident or mishap. Excluding certain types of loss which by law or custom are considered as falling exclusively within the scope of other types of insurance such as fire or marine. Coverage of casualty insurance. 1. Personal accident insurance, a form of insurance which undertakes to indemnify the assured against the expense, loss of time, and suffering resulting from accidents causing him physical injury. Usually by payment at a fixed rate per week while the consequent disability lasts, and sometimes including the payment of a fixed sum to his heirs in case of his death by accident within the term of the policy. 2. Public utility insurance, indemnifies against liability on account of injuries to the person or property of another. It may extend to automobiles, elevators, flywheels, libel, theaters, and vessels. 3. Plate glass insurance. An insurance against loss from accidental breaking of plate glass windows, doors, showcases, etc. 4. Employer's liability and workman's insurance. The risk insured against is the liability of the assured to make compensation or pay damages for an accident, injury, or death, occurring to a servant or other employee in the course of his employment under statutes imposing such liability on employers. 5. Motor vehicle liability insurance, is a contract of insurance against passenger and third-party liability for death or bodily injuries and damage to property arising from motor vehicle accidents. Aside from compulsory motor vehicle liability insurance, the Insurance Code contains no other provisions applicable to casualty insurance. Therefore, such casualty insurance are governed by the general provisions applicable to all types of insurance, and outside of such statutory provisions, the rights and obligations of the parties must be determined by their contract, taking into consideration its purpose and always in accordance with the general principles of insurance law. 6. Burglary and theft insurance, an insurance against loss of property by the depredations of burglars and thieves. 7. Health insurance, an indemnity to persons for expense and loss of time occasioned by disease. Health and accident insurance are either covered under life or casualty insurance. Seconds. 174. 8 other substantially similar kinds of insurance. 2 divisions of casualty insurance. 1. Accident or health insurance, insurance against specified perils which may affect the person and/or property of the insured. 2. Third-party liability insurance, insurance against specified perils which may give rise to liability on the part of the insured of claims for injuries or damage to property of others. Accidental vs intentional as used in insurance. Accident intentional. The terms accident and accidental have been taken to mean that which happens by chance or fortuitously, without intention or design, which is unexpected, unusual, or unforeseen. Intentional as used in an accident policy, excepting intentional injuries inflicted by the insured or any other person, implies the exercise of the reasoning faculties, consciousness, and volition. Rules on third-party liability insurance. 1. Insurable interest is based on the interest of the insured in the safety of the persons, and their property, who may maintain an action against him in case of their injury or destruction respectively. 2. In a TPL insurance contract, the insurer assumes the obligation by paying the injured third party to whom the insured is liable. Prior payment by the insured to the injured third person is not necessary in order that the obligation of the insurer may arise. The moment the insured becomes liable to third persons, the insured acquires an interest in the insurance contract which may be garnished like any other credit. Per la Compagnia de Seguros, Inc. vs. Ramolit, Gr. No. L. 60887, November 13, 1991. 3. In burglary, robbery, and theft insurance. The opportunity to defraud the insurer is so great that insurer have found it necessary to fill up the policies with many restrictions designed to reduce the hazard. The purpose of the exception is to guard against liability should theft be committed by one having unrestricted access to the property. Fortune Insurance and Surety Co. vs. CA, Gr. Number 115278, May 23, 1995. 4. The right of the person injured to sue the insurer of the party at fault depends on whether the contract of insurance is intended to benefit third persons also or only the insured. Eulogio vs. Del Monte, Gr. No. L. 22042, August 17, 1967. If the contract provides for a. Indemnity against third-party liability, the third persons to whom the insured is liable can sue directly the insurer upon the occurrence of the injury or event upon which the liability depends. The purpose is to protect the injured person against the insolvency of the insured who causes such injury and to give him a certain beneficial interest in the proceeds of the policy. It is as if the injured person were especially named in the policy. Schaefer vs. RDC Judge, Gr. No. 78848, November 14, 1988, 1996 bar. V. Indemnity against actual loss or payment. The third persons cannot proceed against the insurer, the contract being solely to reimburse the insured for liability actually discharged by him through payment to third persons. Said third person's recourse being thus limited to the insured alone. Prior payment by the insured is necessary to give rise to the obligation of the insurer. Source of liability of third-party liability insurance. The direct liability of the insurer under indemnity contract against third-party liability does not mean that the insurer can be held solidarily liable with the insured. The insurer's liability is based on contract, that of the insured is based on tort, figuras INVDA. De Molina, E.T. Alvijon Francisco Consolation, Gr. Number 60506, August 6, 1992. Q. Lawrence, a boxer, is a holder of an accident insurance policy. In a boxing match, he died after being knocked out by the opponent. Can his father, who is a beneficiary under said insurance policy, successfully claim indemnity from the insurance company? A. Yes. Clearly, the proximate cause of death was the boxing contest. Death sustained. A. Yes. Clearly, the proximate cause of death was the boxing contest. Death sustained in a boxing contest is an accident. De La Cruz v. Capital Insurance. And Surety Co., Gr. No. L21574, June 30, 1966.